Hi friends, in this video we are going to be talking about a successful case that we got approved, and I also want to share with you what an RFE looks like. Sometimes USCIS will just issue an RFE and they can be quite intensive. So I'm going to share what works and what an RFE looks like, so you're going to want to stay tuned. Hi, my name is Kaushik Ranchhod. I am an immigration lawyer, been practicing for over 20 years, and I have a few gray hairs to prove it. All right, let's get started. The case study that we're going to be talking about is a J1 exceptional hardship waiver case study where our client was from the Philippines. They're a teacher. We do many of these cases. Let's look at the timeline for this case. We filed the case July 25th, 2022. October 26th, 2023, Department of State processed the I-613. Then Department of State issued a favorable recommendation on April 9th, 2024, and USCIS approved the case on April 15th, 2024. So you'll notice here we got the case approved in less than 2 years. Let's look at how we did it. Here, the qualifying relative was the US citizen child. So if you've been watching my videos, you know that you need to have a qualifying relative. The qualifying relative needs to be a US citizen or lawful permanent resident spouse, or a US citizen or lawful permanent resident child. Here we also had a US citizen spouse, and they could not relocate to the Philippines because of a chronic health condition that they have. His health condition required consistent and specialized medical care that was not available in the Philippines. And the American spouse had no ties to the Philippines, spoke only English, and neither he nor the American child had passport. Not only that, the family had no support system in the Philippines, as the J1 holder's parents were financially dependent on the money she sent from the US. The J1 holder was a primary caregiver for their American child because the American spouse worked out of town for 6 months at a time, coming home only on weekends. The American spouse's autoimmune disease was debilitating, and the J1 holder was taking care of the American spouse during the flare-ups that occurred because of the autoimmune issue. Not only that, she helped drive him home for medical procedures, and the stress from potential separation from his family was a critical risk factor that could exacerbate the American spouse's condition. And in this case, we argued that the couple also was planning on having another child. They wanted to have children that were close in age, and if you have family, you may know that you want to have a sibling close in age and not wait many years as a 2-year home residency requirement would impose, because you want to have the siblings play with each other. Without the J1 holder, the American child and any future children would have no one to support them in the Philippines. And we also argued financial hardship. They needed that dual income to be able to support the family. One income was not enough. Here in the United States, there's also a shortage of special education teachers. These are the unsung heroes in the United States. So we also talked about how there was a shortage of special education teachers in the United States. Given all of these circumstances, we were able to develop an exceptional hardship argument through our comprehensive waiver application, our legal brief demonstrating that both relocation and separation would result in exceptional hardship to the American spouse and child. And because of these arguments, we were able to get the case approved. And of course, we like to celebrate. Now you might wonder, why does a case not get approved? Well, I'm going to share with you a request for evidence, and this is going to highlight why USCIS may deny a case. All right, let's look at this application. The RFE reads as follows: hardship claims. An applicant must establish that exceptional hardship would be imposed on a US citizen or lawful permanent resident spouse or child by the foreign residence requirement in both circumstances and not merely in one or the other. Hardship is divided into 2 segments. Consideration must be given to the effects if the qualifying family member was to accompany the applicant abroad for the stipulated 2-year term. Consideration must separately be given to the effects of the requirement should the qualifying family member choose to remain in the United States while the applicant is abroad. Hardship to the applicant is not considered in this matter. So here you can see this is pretty boilerplate language. They highlight the fact that they're not considering hardship to the applicant. However, in our applications, we funnel that hardship to the applicant if there's a child to the child. The RFE goes on as follows: provide a detailed explanation along with specific documentary evidence of the exceptional hardship the qualifying member will suffer because of the 2-year foreign residence requirement. Be sure to address the specific hardships in both circumstances as mentioned above. This application was filed under the basis of exceptional additional hardship to your U.S. citizen child. USCIS acknowledges that some time has passed since the filing of your application and is affording you this time to provide any updated medical evidence as it pertains to your child's health. Here, USCIS has decided that they want updated medical information regarding the medical hardship. They do this on a case-by-case basis, and they arbitrarily decided to do this in this case where they want updated medical information, or they may want updated financial information. While the medical evidence is compelling, you have not provided any current medical evidence demonstrating that your child has been diagnosed with a chronic or severe medical condition which requires them to remain in the United States. If claiming economic or financial hardship, include evidence of the income and savings between you and your spouse, as well as financial records, monthly budget expense. Also provide specific documentary evidence to show the economic and employment situation in your home country. If claiming medical or health hardship, submit a detailed letter from the qualifying family member's physician stating in layman's terms the date of initial consultation, diagnosis, treatment prescribed, duration of treatment, the availability of the treatment in the applicant's home country, and the prognosis and opinion on the ability to travel. So you can see how involved these applications are, because in the filing, we have to address all of these issues. And even if we address all of those issues in the initial filing, you can get a request for evidence and you may have to recreate the arguments if you want to create a thorough RFE response to address all of these issues. I think the request for evidence gives you an idea of what USCIS is looking for, how thorough you have to be in your application preparation and in the RFE response. Typically at our firm, when we respond to the request for evidence, most of our cases do get a favorable approval. I hope that showing both what works and what USCIS is looking for through the RFE, this is going to help you. By taking the time to watch this video, you're bettering yourself. By bettering yourself, you're bettering your family. And by bettering your family, you're bettering the world. Thank you, and bye for now.